On December 2, 2008, police in Rusk County, Texas, found a 13-month-old girl named Amora Carson dead inside a trailer. She had bite marks, broken bones, a cracked skull. Her mother's boyfriend later said he was trying to save her from a demon. 17 years later, Texas put him to death for it. He wasn't the only one. In the next 12 months, Texas executed 4 more men. It almost executed a man for a crime that may never have happened. And it left one man on death row for nearly 50 years without ever giving him a lawyer. This is what the busiest death chamber in America looks like right now. 9 cases, 1 state, 12 months. If stories like this matter to you, hit subscribe before we start. Blaine Milam. On December 2, 2008, 18-year-old Blaine Milam and his girlfriend Jessica Carson walked into a pawn shop in Henderson, Texas, and pawned a chainsaw and an air hammer. They needed cash. They later said they were trying to pay a priest for an exorcism. Back at their trailer in Rusk County was Carson's daughter, 13-month-old Amora. Over the next roughly 30 hours, prosecutors say, Milam beat her with a hammer. He bit her. He strangled her. By the time anyone called for help, the injuries were so extensive the medical examiner couldn't even settle on one cause of death. Skull fractures, broken arms, broken legs, broken ribs, dozens of bite marks. Milam and Carson told police the baby had hurt herself, that she'd been chewing on insulation. They said they'd found her in a hole in the bathroom floor Milam was remodeling. Investigators didn't believe it for long. Surveillance video later placed the couple at a local pawn shop that same morning, selling tools to raise money. They told a Texas Ranger they were saving up to pay a priest for the exorcism itself. Rusk County District Attorney Michael Jamerson prosecuted the case alongside the Texas Attorney General's office. Years later, he admitted he still couldn't pin down a motive. He didn't think the demon story was real. He thought it was cover. Milam was convicted of capital murder in 2010 at age 20. Carson, his girlfriend, was tried separately and got life without parole. For the next 15 years, Milam's appeals rested on 2 arguments. First, that the bite mark evidence used against him was junk science, the same kind of forensic technique a 2016 Presidential Science Council report called scientifically unreliable. Second, that Milam himself was intellectually disabled, and the Constitution bars executing people who are. Both arguments failed. On September 25, 2025, Blaine Milam was pronounced dead at 6:40 p.m. after a lethal injection at the Huntsville Penitentiary. He was 35. Jamerson watched the execution. Afterward, he told reporters, "We will never know what Amora would have contributed to our world." That's the sentence the state wants you to walk away with. But notice what got Milam convicted in the first place. Bite marks. The same kind of evidence experts had spent a decade warning courts to stop trusting. Milam's execution didn't just close a case from 2008. It carried a forensic method the scientific community had already started to abandon all the way into 2025. Texas didn't reconsider. It carried out the sentence anyway. He wouldn't be the last man executed on evidence that doesn't hold up quite the way it used to. Texas executes more people than any other state in the country, and it's not close. Since the death penalty came back in the 1970s, Texas has carried out roughly a third of every execution in America, more than the next 4 states combined. So when something in this system goes wrong, or almost goes wrong, it usually happens here first. That's what the rest of this list is about. Milam's case showed how old evidence can still carry the full weight of a death sentence. The next case shows something else, how a man can escape the system once, get sentenced to death twice, and still end up on the gurney 30 years later. Charles Victor Thompson. On April 30th, 1998, 27-year-old Charles Thompson drove to his ex-girlfriend's apartment in a Houston suburb. He'd already been there once that night and gotten into a fight with her and her new boyfriend, Darren Kane. A police officer had escorted him off the property. He came back anyway. Early the next morning, Thompson shot Kane twice in the chest. Kane turned to run. Thompson shot him again, in the back, then held the gun to the back of his neck and fired once more. Then he shot his ex-girlfriend Denise Hayslip in the mouth. She was airlifted to a hospital. She died a week later. A jury sentenced Thompson to death in 1999. He never disputed shooting Kane, but claimed self-defense. He also argued Hayslip's death wasn't really his fault, that she would have survived her wound if hospital staff hadn't given her an improper intubation. The jury didn't buy it. 2 years after the sentencing, the Texas Court of Criminal Appeals threw the sentence out anyway, not over Thompson's innocence, but because Harris County prosecutors had used an undercover investigator in a way the court called unconstitutional. Thompson got a new sentencing hearing. In 2005, a second jury sentenced him to death again. And it gets worse. Days after that second sentencing, while still inside the Harris County jail, Thompson put on the civilian clothes he'd worn to his hearings, forged an ID badge claiming he worked for the Texas Attorney General's office, and walked straight out the front door. He made it all the way to Shreveport, Louisiana, posing as a Hurricane Katrina evacuee, before a woman he'd called for money turned him in. The manhunt took 3 days. For 28 years, Thompson stayed on death row. In January 2026, he became the first person executed in Texas that year. He was pronounced dead at 6:50 p.m. on January 28th at age 55. Harris County District Attorney Sean Tier witnessed the execution alongside Hayslip's son, her brother, and Kane's parents. Afterward, he called it justice, a long time coming. Here's what's easy to miss in that quote. The case took 28 years to close, and along the way, the system's own conduct forced it to start over from scratch, and still let the man walk out the front door of a county jail in the middle of doing it. Texas didn't lose Thompson to a legal technicality. It lost him to a costume and a fake badge. Thompson slipped past the system for 3 days. The next case never had anything to slip past. Cedric Ricks confessed almost immediately, and the horror isn't in catching him. It's in what a 12-year-old boy had to do to survive. Cedric Ricks. On the night of May 1st, 2013, in a Bedford, Texas apartment, 38-year-old Cedric Ricks got into an argument with his ex-girlfriend, 30-year-old Roxanne Sanchez. He grabbed a knife. He stabbed Sanchez in the neck, the back of the neck, the chest, her hands, her face. Then he turned the knife on her 2 sons, 8-year-old Anthony Figueroa and 12-year-old Marcus Figueroa. He stabbed Marcus 25 times. Marcus survived by pretending to be his brother. As Anthony was dying, he made a gurgling sound. Marcus later testified that he copied that sound, made the same noise himself, because every time Anthony made it, Ricks stopped stabbing him. So Marcus made the sound too. It worked. Ricks left. Marcus got up and called for help. An 8-month-old baby, Rick's own son, was also in the apartment that night. Ricks never touched him. Sanchez and Anthony died at the scene. The Tarrant County Medical Examiner's Office listed Sanchez's cause of death as stab wounds, blunt force trauma, and asphyxiation. Ricks fled the apartment and, on his way out of state, confessed the killings to his own family over the phone. Police tracked him down and arrested him in Oklahoma days later. A jury convicted him of capital murder in 2014. 12 years later, on March 11, 2026, Texas executed him. He was 51. He'd been 38 at the time of the killings, meaning he spent nearly a third of his life on death row before the sentence was finally carried out. Marcus Figueroa was in the room. He was an adult now, sitting just a few feet from the gurney, old scars still visible on the back of his neck. Ricks looked at him and said, "And to Marcus, I always thought about you, and I'm sorry that I took your mom and your brother away. I hate that you had to experience that. I'm truly sorry for what I've done." There's no institutional twist in this case. No withheld evidence, no forensic controversy, just a boy who learned his dying brother's sound to survive and grew up to watch the man who did it die on a gurney 12 years later. Not every case on this list is about a system failing. Some are just about what people are capable of doing to each other and what a child can survive. Before we get to the case that might be the most disturbing one on this list, a man executed while his own cousin was signing a confession to the crime. Hit subscribe. We track every state's execution and every death row appeal as they happen, and you don't want to miss what happens next in this one. James Broadnax. In 2008 in Garland, Texas, two men robbed a recording studio. They walked away with $2. They left behind two dead bodies. The victims were Stephen Swan, 26, and Matthew Butler, 28, an aspiring Christian music producer and his colleague. 19-year-old James Broadnax and his cousin Demarius Cummings had taken a train into the neighborhood that night looking, in their own words, to rob rich white folks. They found Butler's studio instead. Both men were high on PCP and marijuana. In jailhouse interviews afterward, still under the influence and reportedly on suicide watch, Broadnax told reporters he pulled the trigger and repeatedly said he blanked out and didn't remember the details. He showed no remorse on camera. Cummings, who already had a criminal record, told a similar story. Broadnax did the shooting. At trial, that televised confession became the centerpiece of the state's case. Cummings got life without parole. Broadnax got death. That was the story for 17 years. Then, on February 20th, 2026, with Broadnax's execution date already set, Demarius Cummings visited his cousin's attorney and said he wanted to come clean. In a signed declaration dated March 11th, Cummings admitted he was the one who shot Swan and Butler, not Broadnax. He said the two of them had agreed on a story back in 2008. Broadnax, who had no violent record, would take the blame because Cummings, who did have one, figured he had less left to lose either way. I want to clear my conscience and do not want James to be executed for shooting two people when I was the one who committed those acts, Cummings wrote. He later recorded himself on video from inside prison, saying it out loud. I shot Matthew Butler, Steve Swan. And it gets worse. DNA evidence from the original trial, evidence that was never fully explained to the jury, showed Cummings's DNA, not Broadnax's, on the grip of the murder weapon and inside one victim's pocket. Broadnax's DNA wasn't found on either. Broadnax's attorneys wrote in court filings that the confession was corroborated by the fact that his DNA, and not Mr. Broadnax's, was found on the murder weapon. Broadnax's lawyers filed an emergency appeal. They argued the only direct evidence ever tying Broadnax to the shooting was his own PCP-fueled jailhouse confession, one he says he gave because, at the time, he didn't care whether he lived or died. They also argued prosecutors had struck all 7 black prospective jurors during jury selection, using a spreadsheet that flagged only black names. The Texas Court of Criminal Appeals rejected the appeal on April 7th. The U.S. Supreme Court denied a final request hours before the execution. On April 30th, 2026, James Broadnax was pronounced dead at 6:47 p.m. He was 37. His last words included this: "But no matter what you think about me, Texas got it wrong. I'm innocent. The facts of my case should speak for itself." His cousin's signed confession is still sitting in a Texas court file. So is the DNA report. Neither one stopped the execution. The system had a story it liked. A PCP-addled 19-year-old bragging to a camera, and even a sworn admission from the actual shooter, backed by physical evidence, wasn't enough to make it stop and check twice. Broadnax died on evidence the system never fully explained. 3 weeks later, Texas would execute a man its own prosecutors agreed should have been constitutionally off limits. Edward Busby. In January 2004, 77-year-old retired TCU professor Laura Lee Crane was abducted from a Fort Worth grocery store parking lot. Her killer, Edward Busby, robbed her of $775, then drove her alive in the trunk of her own car across state lines into Oklahoma. He wrapped duct tape around her mouth and nose. She suffocated before he got there. Busby was sentenced to death in 2005. What followed was 2 decades of legal back and forth over a single question. Was Busby intellectually disabled? Because if he was, the Constitution says you can't execute him. The Supreme Court settled that in a 2002 case called Atkins versus Virginia. In 2017, in a case called Moore versus Texas, the court specifically told Texas to stop using its own homemade, non-clinical test for intellectual disability, a set of informal factors Texas courts had invented themselves, and start listening to actual medical standards instead. Busby had already been through this once before. His execution was stayed in 2021 so the Texas Court of Criminal Appeals could review his disability claim in the first place. That review dragged on for years. By 2026, there was no real dispute left. 2 independent experts evaluated Busby, one hired by his own defense, one hired by the Tarrant County District Attorney's Office. Both reached the same conclusion. Busby met the full clinical criteria for intellectual disability. The state didn't even seek a third opinion. Prosecutors agreed with the finding. Texas scheduled his execution anyway. On May 8, 2026, a 3-judge federal appeals panel stepped in and stayed it. 6 days later, the U.S. Supreme Court lifted that stay over the objections of 3 justices, clearing the way. On May 14, 2026, Edward Busby was pronounced dead at 8:11 p.m. He became the 600th person executed in Texas since the state resumed capital punishment in 1982. In his final statement, he apologized again and again. "I am so sorry for what happened," he said. "Miss Crane was a lovely woman. I never meant anything bad to happen to her." The Texas Coalition to Abolish the Death Penalty put it plainly afterward. The state's own courts, they said, had disregarded unanimous expert findings and substituted their own non-expert views, the exact kind of reasoning the Supreme Court had already ruled out. In Atkins, the court barred executing people with intellectual disability outright. In Moore, it told Texas, specifically, to stop relying on lay intuition about who really seems disabled and defer to clinicians instead. Busby's case had both sides' clinicians agreeing, and it still wasn't enough. 600 executions, a milestone. The state reached by executing a man both sides had already agreed shouldn't have been eligible in the first place. Milam, Thompson, Ricks, Broadnax, Busby, 5 men, 5 death chambers, 1 year. But an execution isn't the only way this system reveals what it's made of. Sometimes the story is what almost happens, and sometimes it's what the system simply forgets to do at all. Roberson. In 2002, in Palestine, Texas, Roberson's 2-year-old daughter, Nikki, died. She'd been sick for days with a high fever the family didn't know was pneumonia. She fell out of bed. Roberson rushed her to the hospital. Hospital staff didn't know Roberson had autism. They read his flat, unemotional reaction to his daughter's death as suspicious. Prosecutors built a capital murder case around a diagnosis called shaken baby syndrome. The theory that Nikki's injuries could only have come from violent shaking. Roberson was convicted and sentenced to death in 2003. Over the next 20 years, the science underneath that diagnosis started to fall apart. More than 30 international medical and scientific experts eventually wrote to Texas's parole board, arguing the original autopsy conclusions weren't reliable. New evidence suggested Nikki actually died from severe, undiagnosed pneumonia, made worse by respiratory suppressing medication doctors had prescribed her in her final days. 10 independent pathologists later signed a joint statement calling the original medical examiner's report, the one that concluded Nikki died of blunt force head injuries, simply not reliable. Roberson would have been the first person executed in the entire United States specifically for a shaken baby syndrome conviction. His execution date came up in October 2024. It was stopped less than 2 hours before it was set to happen, not by a court, but by a bipartisan group of Texas lawmakers, Republicans and Democrats together, who issued a legislative subpoena demanding his testimony before a House committee. That subpoena forced the Texas Supreme Court to intervene and issue an emergency stay while it sorted out the resulting separation of powers fight between the legislature and the courts. A year later, Texas set a new date, October 16, 2025. And it gets worse before it gets better. The state's own Attorney General's office had specifically requested that date, despite Roberson's appeals still sitting unresolved in court. 1 week before, on October 9, 2025, the Texas Court of Criminal Appeals granted a stay and sent the case back to the trial court. Judge Burt Richardson wrote in his opinion that a death sentence is final, and once it's carried out, hindsight is useless, so the standard of proof needs to match the stakes. Robert Roberson is still alive as of this recording. His case is back in Anderson County, waiting on a judge to decide whether the evidence that convicted him still holds up. Twice now, the system has scheduled his death. Twice, something outside the normal legal process. Lawmakers, then a last-minute court reversal, has had to step in to stop it. Roberson's case turned on a diagnosis that changed. David Wood's case turned on evidence the state didn't want tested. David Wood, between May and August of 1987, 6 young women and girls disappeared near El Paso, Texas. Their bodies were found buried in the desert outside the city. Investigators called it the Desert Killer case. In 1992, a jury convicted David Wood of all 6 killings, based heavily on testimony from jailhouse informants. He was sentenced to death in 1993. Wood always said he was innocent. One man who was jailed alongside him later said police pressured him to falsely claim Wood had confessed to all 6 murders behind bars, a claim that, if true, means part of the case against Wood came from a fabricated jailhouse informant story. For years, nobody could test the physical evidence well enough to know for sure. DNA technology in 1987 wasn't there yet. In 2010, a court finally allowed testing on a few pieces of evidence. 2 results came back inconclusive. The third, a blood stain on one victim's clothing, excluded Wood entirely as the contributor. His attorneys spent the next decade and a half fighting to test the rest, more than 100 additional pieces of evidence that had never been through modern DNA analysis. Prosecutors fought back just as hard. In 2024, the Texas Court of Criminal Appeals unanimously rejected Wood's latest request for further testing. One of Wood's lawyers, Gregory Wirtschach, put it plainly to a reporter: "If they are convinced that David Wood is the desert serial killer, then let's test. Let's use the DNA testing that we have, the most powerful crime-fighting tool at our disposal, and let's use it." The state kept declining. Wood's execution was scheduled for March 13, 2025. 2 days before, the Texas Court of Criminal Appeals granted a stay. The order didn't say which of his 8 legal claims the court found convincing, only that something in his case was serious enough to stop the clock. In July 2025, the case was formally sent back to the trial court. As of this year, a hearing on his claims is tentatively set for June 2026, nearly 40 years after the murders he says he didn't commit. David Wood has now spent more than 3 decades on death row for 6 deaths where the physical evidence, when it's actually been tested, has pointed away from him. Texas came within 48 hours of executing him anyway. Wood is still waiting for his hearing. So is a woman whose conviction has already been thrown out once and put right back on the table by the same court that threw it out. Brittany Holberg. In November 1996 in Amarillo, Texas, 23-year-old Brittany Holberg killed 80-year-old A.B. Towery inside his apartment. She stabbed him 58 times and pushed part of a broken lamp down his throat. She said she acted in self-defense, that Towery, a former client from her time as a sex worker, had attacked her first. Prosecutors said it was a robbery. A jury sentenced her to death in 1998. The case against her leaned heavily on one witness, her jail cellmate, Vicky Kirkpatrick, who testified that Holberg had told her she enjoyed killing Towery and would do it again for drugs or money. That testimony directly contradicted Holberg's self-defense claim. What the jury never learned was that Kirkpatrick was a paid police informant for the Amarillo Police Department, working other cases at the very same time, and that she was released on bond the same day she gave her statement against Holberg. In March 2025, a three-judge panel on the U.S. Fifth Circuit Court of Appeals threw out Holberg's conviction entirely. Judge Patrick Higginbotham didn't hold back. He called the case a showcase of prosecutorial misconduct and wrote that the state's suppression of evidence had prejudiced her case. Texas asked for a do-over. It got one, an en banc rehearing, meaning all 17 judges on the entire Fifth Circuit, not just 3, reconsidering the ruling. That's a rare move. It happened on January 21, 2026, in a courtroom in Louisiana, with judges spending most of the hearing picking apart the credibility of a single informant from 30 years ago. As of this recording, the full court still hasn't ruled. Brittany Holberg has spent close to 30 years on death row over a trial that one federal panel already said wasn't fair, and the system still hasn't decided if it agrees. Roberson, Wood, Holberg, 3 cases stuck in appeals, their outcomes still undecided, but at least somebody is fighting for them. The final case on this list spent nearly 4 decades with nobody fighting for him at all. Clarence Curtis Jordan. In 1977, 21-year-old Clarence Curtis Jordan shot and killed a Houston grocer named Joe Williams during a burglary. He was sentenced to death in 1978. By then, Jordan had spent most of his life dealing with hallucinations and severe intellectual deficits. His IQ placed him in the bottom half of 1% of the population. He believed the President of the United States was a man named John Hill. He said he regularly saw, in his words, old, weird, burnt-up-looking people watching him. None of that came from a diagnosis made after his arrest to build a defense. It was already documented, years before the shooting, in his medical history. In 1988, the Texas Court of Criminal Appeals ruled Jordan was incompetent to be executed. That should have been the beginning of a resolution. Instead, it was the start of nothing. Jordan didn't get a new sentencing hearing. He didn't get moved into a hospital system. He simply stayed on death row, and somewhere in the paperwork, he lost his lawyer. Nobody replaced one. For the next 36 years, Clarence Curtis Jordan had no attorney at all. It wasn't until 2024 when Harris County started auditing a massive backlog of delayed criminal appeals, some of them lost or ignored for more than a decade, that anyone noticed Jordan was still there. A new attorney, Ben Wolf, took the case. Wolf runs the state's Office of Capital and Forensic Writs, the office responsible for representing death row inmates just like Jordan. He was warehoused and forgotten all of these years unconstitutionally, Wolf said. It's a really sad case. He's been on death row basically as long as I've been alive. On April 9, 2026, Jordan's 70th birthday, the Texas Court of Criminal Appeals vacated his death sentence. The court found that the jury at his original trial had never been properly instructed to weigh his mental illness and intellectual disability as reasons for mercy. The Harris County District Attorney's Office, to its credit, didn't fight the ruling. In a public statement, the office said the outcome was what justice looks like, while carefully adding that Jordan's underlying conviction still stands. 2 months later, a state judge formally resentenced Jordan to life in prison, with the possibility of parole. The judge also recommended him for medically supervised early release. He's bedridden now, following a stroke. Jordan's case wasn't an isolated clerical accident. It surfaced during a county-wide review that turned up numerous other delayed capital appeals in Harris County, some abandoned for more than 10 years at a stretch. Jordan just happened to be the one who'd been waiting longest. 47 years on death row, 36 of them without a single person assigned to defend him, in the very same county that has sent more people to Texas's death row than any other in the state. Nobody in Harris County tried to execute Clarence Jordan faster. Nobody tried to execute him at all. The system just stopped looking. It took a county-wide audit, 36 years later, to notice a man was still sitting there, waiting for a lawyer who was never going to come on his own. Jordan's case wasn't an isolated fix. It surfaced because Harris County had begun auditing its own backlog of capital appeals and found more than his file sitting untouched for years, some abandoned by attorneys who'd simply stopped filing paperwork, others left with no lawyer of record at all. That audit is still ongoing and active right now. Nobody yet knows exactly how many more men like Clarence Jordan are still sitting somewhere in the Texas system, forgotten, waiting on a lawyer who was never assigned. 9 cases, 5 executions, 3 men still waiting on appeal. 1 man who almost slipped through the cracks entirely and only didn't because somebody happened to go looking. Texas currently has about 165 people left on death row. That's the smallest that number has been since 1985. Smaller death row, same busy death chamber, and, if Clarence Jordan's case is any indication, still no guarantee everyone on it has a lawyer checking in. Roberson, Wood, and Holberg's cases are still open right now. If you want to see how they end, subscribe. We'll cover the rulings the moment they come down. Thanks for watching.